Okay. Good afternoon. On behalf of the California Department of Justice and Attorney General Rob Bonta, welcome to today's public meeting. My name is Stacy Schesser, and I am a Supervising Deputy Attorney General with the Department of Justice. Up here with me are my colleagues, Senior Assistant Attorney General in charge of Consumer Protection, Nicholas Akers, and Daniel Dubois, Attorney General in the Consumer Protection section. Today's meeting is a preliminary meeting that the California Department of Justice is conducting as we begin our mandated rulemaking required by the Protecting Our Kids from Social Media Addiction Act. This law, also known as Senate Bill or SB 976, was passed by the California legislature in 2024 and signed by Governor Gavin Newsom on September 20th, 2024. The Act places restrictions on online platforms that provide addictive features accessible to minors in California. Under the Act, the Attorney General is required to promulgate regulations or make rules in furtherance of protecting minors from these addictive features on online platforms. We have not yet started the formal rulemaking process under California's Administrative Procedures Act. Today's meeting is the opportunity for the public to provide input and share thoughts on what the rules should state in the specific areas that are required for rulemaking. There will be additional opportunities for public comment as this is the beginning of our rulemaking process. Once the office publishes our notice of proposed rulemaking, we will hold a formal hearing on the text of the proposed rules, and the public can again provide oral comments or submit written comments to our office. During the formal rulemaking process, the most helpful public comments include suggestions on the proposed regulatory text or provide alternative language. We greatly value your perspective. For today's meeting, could you please advance to slide 2? We are seeking public comment on specific aspects of the Act that require the Attorney General to issue regulations. These areas include methods and standards to determine a user's age and examples of these methods and standards, ongoing obligations for operators conducting age assurance, data privacy considerations in age assurance, preventing fraud and falsification in age assurance, verifiable parental consent, impacts of the regulations on non-discrimination characteristics as set forth in Civil Code Section 51, and exceptions to statutory requirements. Can you please advance? Today's meeting will be recorded, and we respectfully ask, but do not require, that you identify yourself when you make your comment. To ensure that each member of the public has an opportunity to provide comments, we are setting a time limit for each speaker of 3 minutes. For those who are here in the meeting room, we ask that you line up in number order and speak directly into the microphone so that others can hear your comment on Zoom and we can record your comment. For those joining via Zoom, please use the raise hand function to let us know that you wish to comment, and we will place you into a queue after we hear from speakers who are present today in the room. We are not able to answer questions, and we are not going to respond to your comments today, but we appreciate your input. We may ask a follow-up questions if we have to clarify our understanding. To the extent that you seek to comment on the Protecting Our Kids from Social Media Addiction Act itself, while you are free to state your position, please remember that the law itself has been passed by the legislature and signed by the governor. The Attorney General's office is now tasked with adopting regulations as required by the law. Finally, if you would like to send written comments today, you can always email them to sb976@doj.ca.gov. We ask that you submit the comments by November 15, 2025 for our consideration. The last thing is I would request that you please silence your phones so as not to interrupt our speakers today. With that, we are eager to get started. So please, the individual that received the number 1 card, please approach the microphone so that you could get us started with your public comment. Thank you. Hi, right over there. Yeah, thank you.
to the public comments outlining.
The areas, sure.
Or we heard to address a few.
You'll have to speak up because the microphone is over there.
Oh, the microphone's there.
Yeah.
Actually, if you want to just come
Yeah,
back
I
and
can-
stand right in the middle, that's fine. Thank you. Sorry.
We're in the red.
So my name Brandon Chen. Here to talk about a few comments for a few of these bullet points here, including methods and standards determining users' age with examples, as well as data privacy considerations for age assurance and preventing fraud or falsification in age assurance. I think it'd be helpful for companies that need to comply with these regulations to align with international standards. One of the international standards that I'm referring to, or to be more specific, is the ISO 25766. I see you nodding, so it looks like you all are well aware of this as well. I'm sure you also are also aware of other regulatory bodies, including Australia's E-Safety Commission, that drafted their regulatory guidelines in accordance with these set of ISO standards that have just entered the beginning stages of publication. Also related, any follow-up questions before I go to the next point? Also related to this set of standards is making sure that we're applying the concept of successive validation or a waterfall approach to any of the age assurance methods used, whether those are age inference, age estimation, or age verification methods. This should be applied with consistent to an approach such as Australia, where they're able to apply a few different methods to understand whether users should be have their age verified or validated at all, focusing especially more on high-risk accounts or use cases. Applying age assurance to low-risk contexts, such as accounts that have already created, were already created 13 or 16 or however many years ago, adds limited safety benefit, but creates unnecessary burdens for users and platforms. And finally, is providing choice of and proportionality in methods should be incorporated into the final requirements for companies that need to comply as well. Public policy should enable a wide range of approved age assurance methods, covering those areas that I mentioned before, ranging from estimation to inference to verification, to ensure flexibility, not just for end users, but also organizations applying them, for them to better curate the end user experience, to ensure not only compliance, but also ensure that users are able to comply with this regulation to prove age. These multiple verification approaches could include device-based checks or credential or attribute attestations. And in doing so, it can promote inclusivity to uphold technological neutrality. All I have.
Thank you.
Thank you.
Speaker number 2.
Stand over here. Yeah.
Right there's fine.
Okay, great.
Yeah.
Thank you so much for having me. My name is Kate, and I'm the director of a research program called COSPER for Children's Online Safety and Privacy Research, and I'm also based in Oakland here. I want to really challenge moving ahead with age assurance, given that there's very little scientific backing about its accuracy. In fact, research from 2024 said that the software demonstrates racial bias, detecting Caucasian faces a lot more accurately and lowest accuracy for the African category, and displaying age and gender bias, particularly with lower accuracy for young males compared to young females. In addition to that, I think this proposed bill is a missed opportunity to make social media companies answer for the harm that they've caused. And the bill should really focus on prohibiting the predatory business practices that take advantage of young people. So I want to highlight 3 interventions that I would really like to see this bill take on. One is to intervene by prohibiting manipulative features. And these are things like endless scrolling, autoplay features, and frictionless recommendations that prolong user engagement that are directed particularly at young people. Second is to prohibit companies from displaying advertisement and sponsorship content at the top of their feed. And this is because users are often showered with advertising content, because that very much is how social media companies make money. And finally, SB 976 should really prevent companies from collecting engagement metrics to design and deploy user feed. So these are features like read receipts, pending speech bubbles, and live sentiment feedback and notifications to reply. And these are deployed specifically to create social pressure, incentivizing young people to stay on platforms longer and to continue responding. So these are the three kind of features and the business models that social media companies deploy. That this particular act that's so concerned with social media addiction should really be addressing, rather than age assurance, which again has very little scientific backing to show that it's accurate, let alone enforcement. So I'll pause there and happy to answer any questions. Thank you.
Any other speakers in the room? Thank you.
Hello, thank you for your time and for running this event. My name is Joe Newman. I'm here on behalf of KID. We're a company that enables age-appropriate experiences for publishers and platforms, allowing them to easily adapt by age and location, solving for regulatory fragmentation, and enabling a safer and more empowering internet. As part of our work, we work closely with a number of age assurance providers. We operate as an orchestrator or clearinghouse of a number of different vendors. So we very much appreciate California's willingness to dive into the space and to provide some clear rules. From our perspective, we and our clients are very concerned about friction, privacy, security issues associated with age assurance, particularly when users must verify their age multiple times for every social media service that they use. So what we would like to ask the California DOJ to consider supporting a neutral, interoperable, privacy-preserving age assurance solution, for example, via a reusable passkey technology. So similar to what has been endorsed by the Brazilian ANPD and ARCOM in France. It is now being promulgated throughout the EU. So our view is that passkey technology is the best solution for user adoption and use. It's cheaper to implement at scale, and it is the most secure and privacy-preserving approach available for age assurance. We are actively supporting a public interest initiative on these principles that will be announced next week or possibly Friday, that proposes a common framework for privacy-preserving, interoperable, and dedicated secure age credentials. The technology enables users to rapidly prove their age without having to share their identity. Happy to answer any questions that the DOJ has about the technology and why we think that it will be so pivotal to the age assurance discussion.
Thank you.
Thank you. Any other speakers in the room? Public comment? No? Okay, online, the first commenter, let me get my. My time about so. Okay, our first speaker will be Mark Roberts. Mark Roberts, you have 3 minutes and you allowed to talk. You have been unmuted. You now have 3 minutes to speak. Mark Roberts.
Okay, can you hear me?
Yes. Thank
Okay,
you.
perfect. Good afternoon. Hi, I am Mark Roberts from the Age Verification Providers Association. We represent over 30 companies around the world that build the technology for privacy-preserving, non-burdensome age assurance solutions used by major platforms around the world. California's SB 976 offers a major opportunity to protect children from social media addiction, but the success definitely depends on the implementation. The regulations that get put forward need to encourage flexibility, privacy, and risk proportionality rather than being a one-size-fits-all rule. The Supreme Court's decision in the Free Speech Coalition versus Paxton case sets the constitutional guideposts, and regulation is permissible if it serves a compelling interest and also minimizes incidental burdens on adults. So that's precisely the balance that we need. If age assurance systems are near frictionless, privacy first, and broaden the choices made available to users, then this bill should not only be able to achieve the protection of minors, but also withstand constitutional scrutiny. We know that today's combination of technologies work. Recently, the Australia Age Assurance Technology Trial showed that over a dozen solutions, ranging from AI age estimation to document and signal-based checks, met strong standards for accuracy and privacy. Their conclusion was clear: there is no one-size-fits-all method, but that highly effective age assurance absolutely can be reasonably achieved through a range of effective options that platforms can tailor to their risk profile. Also, the UK's Online Safety Act provides similar proof. Large platforms like Reddit and Roblox have already rolled out age assurance at scale, demonstrating that this is both technically feasible and user-friendly. By contrast, protections based only on parental consent or self-attestation both fail the tests. It's less reliable for safety and more burdensome for parents, users, and platforms. We believe that California should embrace a risk-tiered, technology-neutral model which provides lighter and low-friction methods for the general content and then stronger checks for high-risk or addictive features, all built on privacy preservation, transparency, and independent certification. That's how to best to achieve safety and safeguard civil liberties. Our ask to the DOJ is this: ensure that SB 976 regulations explicitly recognize and permit the full spectrum of privacy-preserving age assurance technologies that are available today, so that each platform can adopt the solutions most appropriate to the risks present. California has a chance to lead globally and ultimately help to prove that protecting children and protecting privacy are not opposing goals, but rather two sides of the same principle: responsible, rights-respecting digital design. We're more than willing to engage further as needed, and I would like to thank for this opportunity to weigh in today.
That's the time.
We let him finish.
Yes. Yeah, he can finish it. If
Yeah.
that's up to you.
Sorry, could you please conclude?
Oh, that was it.
Okay, thank you.
Thank you.
Okay, our next speaker online is Holly. Holly, you've been unmuted. You have 3 minutes to speak.
Good afternoon. My name is Holly Grosshans, and I am Senior Counsel for Tech Policy at Common Sense Media, an organization dedicated to improving the lives of children and families through trustworthy information, research, and advocacy. We supported SB 976 as it moved through the legislature, and we continue to support the DOJ's work to ensure that this law is implemented in a way that protects kids while also safeguarding privacy. The data tells a clear story. According to the United States Surgeon General, 95% of teens use social media, and more than a third are online almost constantly. Teens who spend more than 3 hours a day on social media are twice as likely to experience symptoms of depression and anxiety. Social media companies intentionally use algorithmic addictive feeds to keep young people scrolling longer to boost their profits. Those design choices have had devastating consequences, including higher rates of depression, anxiety, self-harm, and suicidal ideation among children and teens. SB 976 took a direct aim at that problem, and it doesn't limit content or speech. Instead, it targets the addictive design features that exploit kids' attention. The law ensures that these feeds are turned off for minors, and that minors enjoy heightened privacy settings by default, with parents empowered to opt in if they choose. As the department begins this rulemaking process, we urge you to adopt strong standards for compliance. Any age assurance system used under this law should be privacy protective, accurate, fair, and independently verified. These systems should minimize data collection and be proportionate to the risks they address. Platforms should also have an ongoing obligation once they know a user is a minor. If a company later learns that a user previously identified as an adult is actually under 18, it should immediately apply the law's protections. After January 1st, 2027, operators should default to treating users as minors unless they can reasonably verify otherwise. We also believe the parental consent process must be truly informed and accessible. Parents should clearly understand what it means to enable an addictive feed or turn off a private mode. Consent should be easy to give and just as easy to withdraw, and companies must not use manipulative dark patterns to make that harder. All this information should be clear, multilingual, and easy to understand so that every family in California can make informed choices. SB 976 is a landmark step toward designing technology that supports rather than exploits our kids. Common Sense Media appreciates the department's leadership and stands ready to work together to make sure these protections are implemented effectively and fairly. Thank you for your time and for your commitment to protecting California's children online and for this opportunity to comment today. We will be supplementing this comment with our written comments.
Thank you. Our next speaker is Juliana. Juliana, you have been unmuted. You now have 3 minutes to speak.
Hello, can you hear me?
Yes.
Okay, hi, good afternoon, thank you. My name is Juliana Arnold, and I'm both a parent advocate and a representative of Parents Rise, a national survivor parent-led movement working to make the digital world safe by design. I'm also here as a mother who lost a child to technology-enabled harm. And I can tell you, these are not accidents. The features that addict and exploit our kids are engineered that way. I advocate with survivor parents around the country who have experienced the deathly harms that could have been prevented with common safety provisions. That's why we would like to express our strong support for the full and forceful implementation of SB 976, the Protecting Our Kids from Social Media Addiction Act. This law is an essential step toward putting child safety before corporate convenience, and I urge the department to adopt strong, clear regulations that fulfill this intent. First of all, we must acknowledge that the harms that children face online are not accidental, they are engineered. Addictive design features, algorithmic targeting, and manipulative interfaces are deliberate choices that exploit young minds. SB 976 gives California the chance to stop that cycle through meaningful age assurance, transparent standards, and real accountability. Secondly, parents cannot carry this burden alone. We're told to monitor and limit our kids' screen time, but no amount of supervision can overcome products that are unsafe by design. The responsibility for safety must rest with the companies that profit from children's attention, not with the families left to pick up the pieces. Thirdly, we need to confront the next frontier of artificial intelligence. AI-powered chatbots and companions are already reaching minors without verification, simulating human relationships and exposing children to emotional and sexual manipulation. We must ensure these systems are off limits to minors and that companies are held liable when they cross that line. I speak as a mother who lost a child to technology-enabled harm. Every delay in oversight, every loophole in enforcement represents another child at risk and another family forever changed. We must enforce strong, independent age assurance and consent standards, prohibit AI systems that simulate human relationships with minors, and hold platforms responsible when their design foreseeably harms a child. This is our moment to ensure that technology serves children, not the other way around. Thank you very much for your leadership, and I thank you for the families of Parents Rise that I had the opportunity to speak. Thank you.
Thank you for your comment. Our next speaker is Rin. Rin. Rin, you have been unmuted. You now have 3 minutes to speak.
Good afternoon. Thank you for the opportunity to comment today. My name is Rin. I'm testifying on behalf of the Electronic Frontier Foundation regarding the proposed rulemaking on SB 976. While we appreciate the Department of Justice's focus on protecting young people and ensuring non-discrimination, we believe SB 76 core requirement of mandatory age verification systems raises serious constitutional and practical concerns. As the department knows, EFF has supported challenges to SB 976 because it violates the First Amendment, and we believe no amount of rulemaking can cure those constitutional flaws. We urge the department to recommend that lawmakers reconsider this approach. EFF is particularly concerned about the discriminatory impact of the age assurance methods contemplated by the law. Every available method, whether biometric, document-based, or financial, systemically harms or excludes marginalized communities along the lines of race, disability, gender identity, immigration status, and class. Studies, including a recent National Institute of Standards and Technology report, show that age estimation technologies are deeply flawed. They have high error rates, sometimes exceeding 40% for 17-year-olds, perform worse for people of color, particularly Black and Asian individuals, and often misclassify transgender and non-binary people. Document-based verification methods fare no better. Millions of adults lack government-issued IDs, including many Black Americans, immigrants, and people with disabilities. 43% of transgender Americans lack documents that correctly reflect their name or gender, and financial verification systems would include the 20% of households without credit cards. These methods would create insurmountable barriers to participation for entire communities. Parental consent requirements raise additional risks. For LGBTQ youth with unsupportive families, such requirements would cut access to affirming and potentially life-saving online resources. They would also exclude young people in foster care or facing homelessness from vital sources of information and community. Across all approaches, these systems are either unworkable or discriminatory. The question isn't whether they will discriminate, but how extensively. When compliance with a statute necessarily results in discrimination or the restriction of lawful speech, the appropriate course is to recognize that impossibility, not codify harm through regulation. We share the department's goal of protecting young people online, but SB 976 is not the right vehicle. It will disproportionately harm marginalized communities, infringe upon Californians' rights to free speech and privacy, and restrict access to lawful information and support networks. We urge the Department of Justice to recommend that the legislature explore alternative approaches that protect youth without sacrificing civil rights or equality. We provided more detailed analysis in our written comments, and we hope it will inform your decision-making. Thank you for your time and consideration.
Thank you so much for your comment. Our next speaker is Robert Boykin. Robert Boykin, you've been unmuted. You now have 3 minutes to speak.
Well, thank you for your time. Good afternoon, and thank you for the opportunity to comment on SB 976. My name is Robert Boykin. I'm here today on behalf of TechNet, a network of more than 100 companies representing the full spectrum of the American economy, from startups to global leaders in technology, artificial intelligence, and digital platforms. While we appreciate the Attorney General's efforts to implement 976 in a way that prioritizes youth safety online, the statute as written presents significant risk of duplication, consistency, and consequences that could harm and vulnerable youth. First, the timing of rulemaking is premature. SB 976 overlaps with pending litigation in NetChoice versus Bonta and the approaching implementation of 1043, the Digital Age Assurance around age assurance, consent, and algorithmic. This urges the and regulatory framework are resolved to
Mr.
ensure
Boykin?
consistency and clarity.
Mr. Boykin, excuse me, I'm going to interrupt you just for a second. You're a little bit staticky there. Are you using a headset?
No, my internet is, I guess, acting choppy. Sorry. Can you hear me
No
okay
worries.
now?
Continue. Yeah, continue,
Okay.
please.
Second, SB 976 structure could unintentionally harm the very youth it aims to protect: vulnerable teens, LGBTQ plus youth, foster youth, and those from immigrant or low-income families often rely on online communities for connection, education, and mental health resources. We urge the department to adopt flexible, privacy-aware consent mechanisms that reflect California's values of inclusion and autonomy, particularly for older teens. Third, personalization and algorithms are essential tools for safety, not just engagement. Well-designed recommendation systems often help filter harmful or misleading content and promote constructive, age-appropriate experiences. The department should distinguish between features designed to protect users and those that truly risk compulsive use. Definitions of addictive feeds must be precise, evidence-based, and tied to measurable harm, not simply engagement. Finally, we encourage a phased evidence-driven approach. Implementation should align with 1043's interoperable age assurance system and reflect ongoing judicial guidance. Doing so will preserve innovation while ensuring California leads the balanced, practical, and privacy protective rules. Thank you for your time and for your commitment to developing thoughtful regulations that promote both youth safety and responsible innovation.
Thank you so much for your comment. The next speaker is LaShawn Francis. LaShawn, you have been unmuted. You now have 3 minutes to speak.
Great, thank you. Good afternoon. My name is LaShawn Francis, and I am with Children Now. We are a statewide research policy and advocacy organization in California. Children Now supports the goals of SB 976 and strongly recommends that the Department of Justice adopt the provisions within the Children Now sponsored bill AB 1043 WICS as the primary method and regulation with regard to the age assurance requirement in SB 976. Recently signed by the governor after broad bipartisan support in the legislature, AB 1043 establishes a first-in-the-country privacy protective system that distributes the responsibility for age verification between device manufacturers, app stores, and app developers. Specifically, AB 1043 mandates that operating systems and app stores require parents or account holders to input device users' age at device setup, and that operating systems and or app stores share approximate users' age to developers of online products and services prior to minors downloading the apps on their devices. Other age assurance methods fall short in that they can be privacy invasive, like requiring the uploading of government IDs or use of sensitive information to require the collection of vast amounts of personal information acquired through browsing history or other online activity. The mechanism set forth by AB 1043 is different. Age bracket information, which is outside the scope legally protected personal information, is sent through a signal that can only be used for the purpose of age verification. Parents have little incentive to lie about their children's ages at device setup. This is distinct from the current status quo whereby parents are bombarded constantly when their children seek to go online. The current reality is that parents often find themselves overwhelmed and take a blanket approach, either accepting or denying all requests. What the current approach does not take into consideration is the data practices of the apps seeking parental consent, practices which would be illegal if the apps had actual knowledge of a minor's actual age. This is how, apart from being convenient to families, the mechanism set forth by AB 1043 is necessary to effectuate the laws preceding it. It closes the actual knowledge loophole that tech companies have exploited for years without compromising a user's personal data. AB 1043 is the obvious choice to guide the rulemaking process, as the final bill is a reflection of the diverse group of stakeholders from youth-led organizations, family advocacy groups, LGBTQ+ advocacy, and large and mid-sized tech. This collaboration is evident not only from the final support in opposition to the bill, but also from those groups that have taken a neutral position on its passage. For these reasons, we strongly encourage the DOJ to use AB 1043's provisions as the basis for regulatory requirements under SB 976. Thank you for your time.
Thank you for your comment. Our next speaker is Austin. Austin, you've been unmuted. You now have 3 minutes to speak.
Hi, everyone. Thanks for the opportunity to speak today. I'm here on behalf of Internet Works, a group of 27 online middle tech platforms, many of them based right here in California, that help millions of small businesses connect to creators and users every single day. Our mission is simple: to make sure tech policy is right sized for everyone, not just the biggest amongst tech, and that people can safely and privately use their platforms on their own terms. As the department starts looking at SB 976 implementation, we have really one simple message to emphasize. We think it's important to build on the foundation California has just recently created in AB 1043, the Digital Age Assurance Act. This new law is the first of its kind model for private practical age assurance using device level tools instead of intrusive verification methods, and is built through years of collaboration. And we're really proud to have supported this effort in the legislature to balance both a timeline and an implementation model that makes sense for platforms of all sizes. We would also say this deserves some time and space to work through the new rules as they get layered on. This is going to be both a technical challenge and an implementation challenge that's going to take time and collaboration, where all parties are bought into to leading progress towards the right outcomes here. We also want to be careful not to unintentionally block young people from creative, healthy, and supportive spaces they rely upon online. So again, just to reemphasize our messages, we really encourage alignment with AB 1043, a thoughtful compromise that was worked out in the legislature this year, which was simply not in effect when SB 976 was enacted a couple years ago. Thank you.
Thank you for your comment. Our next and the last speaker with their hand raised online is Ronak. You have been unmuted. You now have 3 minutes.
Thank you. Good afternoon. Ronak Delami on behalf of the California Chamber of Commerce. First, while we appreciate the effort to obtain preliminary input from stakeholders before drafting these rules on SB 976, we do believe it's premature given the ongoing litigation in Net Choice versus Bonta, and that stakeholders would be better served by delaying this effort until after critical questions regarding the constitutionality and requirements of the law are resolved. Second, as some of the previous commentators mentioned, California already leads the nation in establishing a thoughtful and privacy protective foundation for digital age assurance through App Store APIs. Additional regulations beyond that framework we believe are unnecessary and could prove counterproductive. While we were technically neutral on that legislation, we do think it's important to note that just last month, the governor signed the Digital Age Assurance Act in AB 1043, which centralizes the age verification process to protect the privacy of both adults and minors. Rather than making parents navigate a feed-by-feed approval process, that law assigns responsibility at the App Store operating system level, and 976 rules should at a minimum allow consent through those same levels rather than individual feeds, in recognition that state lawmakers have designated this mechanism for age assurance since 976 was enacted. We urge you to recognize those protocols as a primary way to comply with SB 976's requirements, ensuring that Californians benefit from a single centralized age assurance process for their families. Next, we ask that any rulemaking prioritize feasibility and flexibility. Rules should allow reliance on commercially reasonable practices and avoid technically infeasible or overly prescriptive standards. Flexibility enables companies to develop controls that are intuitive and age-appropriate rather than confusing or inconsistent. Overly complex requirements would only make it harder for teens and parents to understand and manage their online experiences and create implementation challenges from a workability standpoint. It's also critical that any rules be balanced and consider the privacy rights and interests of teens, including their First Amendment interests. Personalized feeds, for example, help teens foster communities, connect with friends, and explore interests, while also supporting meaningful, relevant, and safer and age-appropriate experiences. They can also help teens from certain religions and protected groups find resources and supportive communities, for example. Many parents, in fact, prefer that their teens see content that reflects their individualized interests rather than whatever happens to be trending broadly in the moment. Eliminating personalization or algorithmic rankings entirely would therefore hinder these beneficial and often more appropriate connections. In addition, overly broad parental consent requirements could create barriers for teens from vulnerable populations, including LGBTQ+ youth and those seeking reproductive or mental health information. Teens often turn to online platforms for information and community, and many stakeholders, both inside and outside the business community, raised these concerns during the passage of SB 976, that the bill could restrict the ability to share or access content without parental consent. For these reasons, we urge you to balance significant First Amendment considerations in any rules you advance. I know my time's running out, so I'll just conclude and mention that we are going to submit our comments in writing as well. Thank you very much.
Thank you very much for your comment. There are no other raised hands online at this time. If you'd like to make a comment, please use the raised hand function on your Zoom screen. And at this time, there are no other hands raised.
Okay, we'll give another 5 minutes to see if any other members of the public walk in or decide that they want to raise their hands. If not, at 1:45, we'll conclude. And so just we thank everybody for their participation at this time and in this process. Your input is valuable as our office begins this rulemaking that the Act requires us to undertake. If you have additional comments, we encourage you to use the email sb976@doj.ca.gov to submit further comments. And we will again wait for 5 more minutes.
Yeah, we have another.
Oh.
comment. Give me just a second. Okay, our next commenter is Beja Springer. Beja Springer, you have been unmuted. You now have 3 minutes to speak.
Thank you. Thank you so much for hosting this public comment. So I am a parent with friends and extended family members that are in the LGBTQ community, and also with an elementary age child who just yesterday in the car was telling me about some really stressful content that he had uncovered on the internet. And so obviously we all know that this is super important. I appreciate some of the public comments others have made about keeping things really simple and systemic for parents to control, to support and protect their kids. Um, just as a parent, um, I am most concerned about harm for my kid. Um, I would, I'm not so worried about whether or not I can get the word out, for example, about the things that I care about to others who might be of a different opinion. And I think that's pretty wordy, but just I really care about kids and their safety. And whatever really puts that as the priority, as opposed to um, uh, uh, a free-for-all and harmful content getting to our kids. I think keeping our kids safe is the most important thing. I apologize, I did not write this script and prepare in advance. So let me repeat that again. Just protecting our kids from harmful content and addiction is the most important piece, and however we get there is the goal. And so just thank you so much. And I'm done.
Thank you so much for your comment.
Thank you.
Okay. There are no other hands raised at this time. Anyone in the room would like to make an additional comment? No.
We'll give folks 2 more minutes. Okay, the time is now 1:45, and given that we have nobody else that would like to speak both via Zoom or in person, we thank you very much for attending this public meeting and have a nice rest of your day. Thank you.
Thank you all.
I'm sorry, do you want to, let me see.
Also, if anyone wants to leave a card, you are very welcome to do so.
Are you just a member of the public, or were you here with an organization? Okay. Do you want to let us know who it was, or persona? Okay, thank you. Thanks, we just didn't say it, so I wasn't sure. Okay, thank you.